Hello friends, in the YouTube channel Advocate Amit Kumar Gupta. Today I am going to discuss a case which has been decided by the Bombay High Court. The matter has been decided in 22nd December 2021 and the matter has been reported in 447 ITR at page number 743. The name of the case is GANGA Iron and Steel Trading Company versus Commissioner of Income Tax, and the matter has been adjudicated by the Bombay High Court. In this case, the assessee was raising a legal ground first time before the Honorable Bombay High Court. First of all, the question was that whether assessee is eligible to claim legal ground at the first time before the High Court if the assessee has not taken this ground in the earlier proceedings before the ITAT or the CIT appeal. So, the answer is in the affirmative, the assessee can do so. In this particular case, the penalty on the assessee was confirmed through a defective notice, and that notice was under section 271 subsection 1 clause C for imposing penalty, and the notice was not clear whether it was for furnishing inaccurate, whether penalty is levied for furnishing inaccurate particulars or for the concealment of income. Although this matter has been decided by various high courts, even the SLP for this matter has been dismissed by the Supreme Court in favor of the assessee, but in these type of cases there are some questions which arises which have been settled by the Bombay High Court in this particular case. The most pertinent question which comes before the courts, that if the assessing officer during the assessment proceedings has mentioned in the assessment order that the assessee has concealed his income or has furnished inaccurate particulars, then even if the notice is not clear about this thing, so whether that notice will prevail in the eyes of the law or not. So on this particular point, the court was very conscious and made some remarkable comments which I am going to deliver before you. First of all, the court said that a penal provision even with civil consequences must be construed strictly. As far as the criminal proceedings are concerned, those provisions are very specific and that should be construed very strictly. But the court said that if the matter is of penalty and if that penalty is of civil consequence, even then it should be construed very strictly. The second thing, the court said that if there is ambiguity, then it should be affected in assessee's favor. Ambiguity means that whether the department wants to levy the penalty for concealment of income or for furnishing inaccurate particulars, when it is not clear, then it should go in the favor of the assessee. The third thing, the court said that assessment proceedings no doubt form the basis of the penalty proceedings, but they cannot be termed as composite proceedings to draw a strength from each other. Meaning thereby that if the assessment order has said that the assessee has concealed his income, but the penalty proceedings does not mention it, so the penalty proceedings cannot take the color from the assessment proceedings. The fourth thing which the court said that each cannot cure the other's defect, meaning thereby that if the penalty proceedings are not clear, then the assessing officer cannot take the benefit by saying that I have mentioned this thing in the assessment order, so it was but natural. So these type of arguments will not prevail in the favor of the department. The next thing is that which the court said that a penalty proceeding is a corollary. Nevertheless, it must stand on its own. Court said that whenever the penalty proceedings are going to be initiated against the assessee or the penalty is going to be imposed on the assessee, then these proceedings should not take the strength from the assessment proceedings. They must stand on their own leg. Next, the court said that penalty proceedings culminate under a different statutory scheme that remains distinct from the assessment proceedings. It is very much clear that assessment proceedings are different, penalty proceedings are different. It may happen that there are some tax liability on the assessee, but it may happen that there are no penalties to be imposed on the assessee. So both are in different perspective, and it cannot be said that the penalty proceedings can take the color from the assessment proceedings. Next, the court said that assessee must be informed of the grounds of the penalty proceedings only through a statutory notice, meaning thereby that the assessing officer cannot say that I have mentioned in the assessment order that you have to pay the penalty according because you have concealed the income or you have furnished the inaccurate particulars. But if the notice for the penalty is defective, then the penalty cannot prevail. Last but not the least, an omnibus notice suffers from the vice of vagueness, meaning thereby that the notice which is saying that penalty for concealment of income / penalty for furnishing inaccurate particulars without striking of the inapplicable part is a vague notice, and it will not prevail in the eyes of the law. So in this particular case, the Bombay High Court said that the notice was defective and the penalty cannot be levied on the assessee under section 271 subsection 1 clause C, where the notice given to the assessee was defective from the inception. At the end of this video, once again I am repeating the name of the case. The name of the case is GANGA Iron and Steel Trading Company versus Commissioner of Income Tax, and this matter has been reported in 447 ITR at page number 743. Thank you, friends.